Hi, my name is Goldman, and I'm an attorney from Goldman & Associates. We had an individual write us a question. And by the way, let me just go off the side and say, if you have any questions about anything you'd like us to discuss, and it could be a discussion between me and you, or it could be something you would like us to make a video out of and share it with the public, just let me know. Email us, call us. You can even say, I'd like Mr. Goldman to do a video about this, and we'll be happy to consider that in addressing the issue for a video. But here's a question that came in, and the question was, when a spouse moves out and leaves everything in the house, are they at liberty to come back and get it later? Well, right, you have to understand something. Until there's a court order that says otherwise, in the marriage, half the stuff is yours, half the stuff is his. You can take whatever you want. There's no order that says that you can't. And if you voluntarily move out of the house, you're at liberty to come back and get it. However, you have to understand something. That once the court orders, for example, that the status quo be maintained and that everything should freeze, you shouldn't be climbing into the living room through the window and taking stuff out or all that, because you're going to get in trouble with the court. That's not the way to do it. Ultimately, if the case is proceeding and you want something specific from the house, you should put it through channels. Let your lawyer know. Your lawyer will tell the other. If they can't, lawyers can't agree that you can take that thing, we'll go before the judge. If it's your personal clothing, for example, or items that you need for your everyday life, there won't be objection. Even if there is, the court's going to allow you to have it anyway. If you find out, for example, that the person who's in the house is, selling stuff on eBay, and you can show the court that things aren't safe with him in the house because he's liquidating all the assets, well, then you have to, again, let your lawyer know, get the judge involved, and they'll put a stop to that. But the short answer to this person's question is, just because you leave doesn't mean you abandon your rights to those things. There's no land rush just because you depart the house, okay? Those things are still yours. And we don't have a concept that you've abandoned it, so therefore they can throw it away or give it away or keep it. You're still entitled to your share of the marital assets. Now, whether or not the thing that you're talking about is something that will go to you at the end of the day, or go to the other person, or be split, that's a different story. But certainly with respect to your own personal things, photos of your, family that the other person won't really care about, family heirlooms, your personal clothing, your shoes, your toiletries, your this or that, even if you leave in a huff and don't take anything, you can certainly ask to come back and take your stuff. Again, if you are denied access, do not take the law into your own hands. Do not break into your house on the theory that it's still your house. You call your lawyer. Your lawyer will in turn reach out to the other lawyer. If they can't agree, it'll go before the judge. And while you may think, well, gee, all that's going to cost me a lot of money. Yeah, what do you think it's going to cost you when you get arrested for breaking into that house and you have to throw bail for yourself? What do you think that's going to cost? Guess what? It's going to be much less expensive to go through channels. If you have any questions about that, reach out, and we'll be glad to help you out. If you found this helpful, please like, comment, and subscribe.